Welcome to Forensic Perspectives, the legal community's online resource for the latest in forensic accounting, business valuation, and financial litigation support. Your host for this podcast is Mark Gottlieb. In addition to being a certified public accountant, Mark has also obtained many professional accreditations in forensic accounting and business valuation. As one of the Tri-State's leading financial experts, Mark is also a frequent lecturer and writer. Without any further ado, please welcome the host of Forensic Perspectives, Mark Gottlieb.
Thank you, and welcome to today's broadcast. A marital dissolution can be a difficult and painful event, even under the best-case scenario. At worst, it can have a profound effect on the divorcing spouses and their children. The traditional approach to divorce involves the involvement of the court system and often leads to a high emotional and financial cost to everyone involved. Recently, many parties have reached for mediation as an alternative process to terminate a marriage. Mediation has become a viable option for those trying to resolve the challenges of a divorce. It may not be suitable for every marital dissolution, but many attorneys and even the court system have become increasingly aware of its benefits. To discuss the topic of mediation in a marital dissolution, I'm happy to welcome attorney I.wmv. Alan is with the firm Halloran & Sage, located in Westport, Connecticut. His practice focuses on family law, collaborative divorce, divorce mediation, and litigation of all divorce-related matters, as well as the representation of children. Alan attended both Brooklyn and Yale Law School and is a member of both the Connecticut and New York State Bar Associations. Alan, thank you for joining us today.
You're welcome. Good to be here.
First and foremost, can you give us a working definition of divorce mediation and explain how it differs from the traditional divorce process?
When I'm meeting with a potential divorce mediation client, I tell them that my job is to help them create a dialogue so that they can resolve all the divorce-related issues. That includes a parenting plan that works for everyone, most importantly the children, discuss alimony, child support, distribution of assets, personal property, life insurance, medical insurance, tax returns, and any other issues that are unique to that particular party situation. The primary differences between that and the adversarial system is that the parties control their destiny. They sit in my office around a round table with some little candies there, and we work our way through all of the issues in a reasonable and conciliatory fashion that addresses all of their needs, whether they be financial, emotional, or psychological.
How do people come to the conclusion that mediation should be considered for the divorce?
People who want to be fair with each other. There are certain prerequisites. Not everyone is right for mediation. I remember when I was a young law student, I met with one of the grand dames of the New York Bar on West 57th Street, and she said to me through a smoke-filled room, if I had a nickel for every husband who wanted to mediate, I could retire. So there is that misnomer out there. Mediation only works for people who truly want to be fair with each other, who have the ability to compromise, and who are willing to be guided through some very unfamiliar terrain by a skilled professional. One common thread among all my divorce mediation clients is that, first and foremost, they want to protect their children. They are terrifically pained by the prospect of divorce, whether they are the initiating or non-initiating spouse. And what's most important for them is to effect as soft a landing as possible for their children and themselves.
Alan, I know there are a number of organizations that train and provide credentials for mediators. Can you walk us through these organizations and describe what training and skill sets attorney mediators have?
My vote is always for an attorney mediator as opposed to a therapist mediator or an accountant mediator or a certified divorce planner mediator. I analogize it to a mechanic. Do you want a mechanic who can fix all of your car, or do you want a mechanic who can only fix the transmission or can only fix 2 of the 4 tires? An attorney mediator can cover all of the issues that are attendant to a divorce. The training varies. I see it. I see them around. There's a lot of programs out there. I think that because somebody does a 40-hour mediation training, that in no way equips them to be a skilled and efficient attorney mediator. My background is somewhat unique in that I litigate cases, I do mediation, I do collaborative divorce. I know what judges do. I know how they think. I know how cases come down, and I negotiate a lot of divorce settlements. Non-attorney mediators don't have that background. I also think one has to have very good listening skills. I remain amazed at how few attorneys have any kind of background in psychology or even an undergraduate or graduate degree in a mental health discipline, because in my view, a lot of the role of a divorce lawyer is one of a counselor to guide people through some very complex psychological and financial issues. And also, many issues in divorce are fed by psychological or interpersonal issues. If the attorney does not have a grasp of what those are and decides not to feed them, as many lawyers do, he or she is less equipped than someone who has that skill set. I remember after the deposition of a client who made quite a bit of money, the other lawyer said to me, well, you know, Alan, the best divorce client, very rich, very angry, and very wrong. I couldn't disagree with that statement more.
Do attorneys who are mediators, do they obtain certain credentials or designations or licenses, or how do they become a mediator? How is a divorce attorney different background-wise or credential-wise from an attorney who practices in the traditional family law setting?
Every divorce mediator that I know, every attorney mediator that I know did at least a 40-hour training. They're a member of one or more mediation groups. They meet regularly with other mediators, and they also do the work, simply put. They are actively involved in the mediation process. I know for me, I have anywhere from 6 to 10 mediations at any point in time, and that's been pretty consistent since I trained as a mediator about 15 years ago. And mediation is very important to them. I only refer mediation clients, if I'm not going to do the work, obviously to other attorney mediators. And when I have review counsel in my mediations, I only refer them to attorneys who either do mediation or are supportive of mediation themselves.
You mentioned when we first started to speak that mediation may not be right for everybody. Are there certain things that are part of a divorce, whether it be simple or complex, that prohibit it from being suitable for mediation? For those of us that practice in the divorced world, we're all familiar that there are certain issues of a divorce, like the disposition of assets, child support, spousal maintenance, other equitable distribution factors. What components of a divorce are most suited for mediation, and what issues prevent it from being useful?
Let me answer the second part first. What really gets in the way of people being able to mediate is the same thing that gets in the way of people being able to resolve their divorces, and that is anger, a sense of loss, a sense of despair, a sense of entitlement or self-righteousness. Any or all of those things fuel adversarial divorce litigation. In mediation, that's a tremendous challenge. The mediations that have not worked for me have been the ones where I discover that someone has a significant personality or mood disorder once we've gotten into the mediation a bit, or someone really has an unjustified sense of entitlement. My mind goes to the 2 or 3 mediations in the past 18 months that did not work out, and in following up with the lawyers subsequent to them, they all settled out right along the parameters of where we ended the mediation. But one party in those 2 or 3 mediations come to mind could not tolerate the idea of finalizing the divorce. And if you think about it, it's really counterintuitive that people who are divorcing, who are so unhappy with each other that they decide to end their relationship and break up their home, that they should be able to sit in a room with each other and discuss these profoundly complicated issues like what happens to our children over the holidays, who pays what, who stays in the house, how are assets divided. So the job of the mediator is to really provide a calm and neutral and safe place where people can explore their feelings about all those issues and come to a reasonable and fair resolution. A very wise family law judge is fond of saying a good divorce settlement is one in which both parties walk away with bearable degrees of unhappiness. I tell people, whether they have no zeros or lots of zeros, that I don't have champagne in my refrigerator. No balloons will come down from the ceiling. We're just here to work out a fair deal that people can walk away and say, that's okay, that works, it's fair given all the circumstances.
Not to dismiss what you're saying, but that is primarily for the emotional part of a divorce, which obviously is going to be there whether divorce takes place under a traditional fashion or divorce or a mediation fashion. Are there components to the divorce that lend themselves to the mediation or prevent the mediation from being an alternative? For instance, if a husband has a multi-million-dollar business, does that mean that mediation is not an alternative? Are there complexities to the mechanics of splitting of the assets, splitting of the kids, and other things in which now this couple is now going to live under two roofs that lend itself to the divorce or prevent it?
I haven't yet run into an issue that we weren't able to address in a mediation. That's not to pat myself on the back, but I think one significant advantage in working with, say, a multi-million-dollar business or a case where there's tens of millions of dollars is that people control their destiny and they control the process. For example, let's just say we've got a business and we need it valued for equitable distribution purposes. We bring in a neutral forensic accountant who does his or her work, again, in a neutral fashion. That person is selected by both parties under my suggestion, and the information that we get from that valuation is neutral. Whereas in an adversarial setting, each person would hire their own forensic accountant, twice or four times the cost, certainly four times the aggravation and time, and then a judge would decide who he or she believes. So, again, with respect to the mediation, the clients, under the guidance of the attorney mediator, can provide appropriate parameters to address the issue, whether it's complex or not. Similarly, in an adversarial setting, you've got to go through 8 steps to get one piece of information. Husband's lawyer says something to husband responds to his lawyer, husband's lawyer goes to wife's lawyer goes to the wife, and back again. Whereas in a mediation sitting around a round table, literally, there's a fluidity to the communication that's only productive.